Welcome to the Tenant Law Podcast, where all types of New York City tenants can learn about the laws that affect their apartments. Rent-stabilized tenants, free market tenants, good cause tenants, luxury tenants, loft law tenants, co-op shareholders, subletters, roommates, co-livers. Let's all learn to live better. Welcome to the Tenant Law Podcast, where we talk about new, interesting, and/or important legal cases affecting New York City tenants. First, we give you some background so you have the context to understand the case we are discussing. Then we talk about the case itself. And finally, we explain why the case is important and give you our tenant takeaway. I am Michelle Itkowitz, and today's case is A3 Investments versus Lynette, a fairly recent Supreme Court case in New York County. First, let's set the stage with some context. We've talked a lot on this podcast about how to prove that warranty of habitability conditions exist in your apartment. This can be important whether you're trying to get the landlord to do repairs or whether you're trying to defend yourself from owing rent. In the rent context, proving how long a condition existed before it got fixed is very important. If you called about a leak on a Monday and it was fixed on the very next Tuesday, then that is less likely to give rise to a rent abatement than if the leak existed for 6 months and you alerted the landlord 6 months ago and the landlord repeatedly did nothing. So let's review. The very best evidence that there's a condition in your apartment that violates the warranty of habitability is that the New York City Department of Housing Preservation and Development inspectors came out and issued a violation. You can cause that to happen by contacting HPD. Evidence of how long a condition has existed might also be established by making a formal complaint on your building's management portal. Not every building is managed with an online portal, however, and pictures and videos with timestamps also really help. Also, in these cases, landlords may admit a condition exists, but they may say that there was a delay in getting it fixed due to the tenant not providing access. That's a big thing in these cases. Or the condition may get partially fixed or seem all the way fixed and then need to be fixed again. That happens a lot with leaks. And these situations can turn into long, complicated stories where facts about who knew what when and who did what when matter and need to be proven in court. One category of proof that's relevant to how long a condition has existed and whether the tenant allowed access and what the exact status of the repair was when is emails, text messages, and other online communications. And that's what the case we're looking at today is about. The tenant lost a lot of relevant text messages about conditions in their apartment because they changed phones and lost text messages. And that's what we're looking at today. So now let's get into today's case. Today's case is a recent case in New York State Supreme Court called A3 Investments SA versus Lynette. It's in New York County. It's a 2023 case, and I will put a link to the case in the show notes. In this case, the tenant was suing the landlord to get out of a 1-year lease after only 4 months because of alleged conditions in the apartment. So this case was in the discovery phase. That's where parties demand information from each other and exchange paper. We don't have a discovery phase in housing court, but this information can still be relevant if you're in housing court. So I'm reading from the case. Quote, landlord asserts that during the course of discovery, repeated demands were made to tenant for text messages on tenant's mobile phones to discern facts about the conditions in the apartment, as alleged by tenant, including tenant's damages and the decision to vacate the apartment early, which was evidence going to the very heart of the case, end quote. So tenant was claiming that the apartment was impossible to live in and that the landlord ignored tenant's repeated pleas to deal with the bad conditions. As part of the discovery in the case, landlord asked tenant for copies of all the relevant text messages. Tenant refused to hand them over because tenant had changed phones and in so doing had lost all the relevant text messages. Landlord therefore asked the court for what is known as a spoilation of evidence sanction against the tenant for failing to cooperate with discovery and hand over the text messages. Tenant says they did not have the requested messages because they changed phones. Landlord says, well, you knew you were going to sue landlord and that there was a lot of text messages relevant to the case on your phone, so you should have backed up those messages before tossing the phone. One more sentence from the case. This is the legal standard for when the duty to hold on to evidence attaches. Quote, once a party reasonably anticipates litigation, it must suspend its routine document retention destruction policy and put in place a litigation hold to preserve evidence. End quote. That applies to texts and emails. So once you know there's a controversy involving your text messages, you need to hold on to those texts and emails about that controversy. Here, the court considered several circumstances, such as the fact that disposing of the phone was more of a mistake and really didn't seem to be intentional here. Although the tenant was still held responsible, the court decided it would give the jury an adverse inference charge, That means that the judge will instruct the jury that the lack of the text messages means that those texts probably would have been bad for tenant and good for landlord. So the sanction to the tenant could have been much, much, much worse. The court could have basically dismissed the case. This gives rise to some interesting tenant takeaways, not only about how to protect yourself here, but also how you can maybe use this rule against your landlord if you need to. But first, housekeeping. This is not legal advice, and I am not your lawyer. But because I am a lawyer, this might be considered legal advertising. If it's legal advertising, it is just terrible because I am asking you not to contact me. Please don't contact me. This pod is not a commercial for me or my law firm. This is simply the podcast that I always wanted to make. Let us know what topics you'd like to hear more about. If you like our work, please give us those 5 stars and put this podcast on your socials. It is time for the tenant takeaway. Tenant takeaway time. First, I remind you that there is a free 30-page booklet available on the Tenant Law Podcast website. I'll put a link in the show notes that talks about how to get repairs and paint jobs in your New York City apartment. It's completely free. It's not advertising anything. You don't even need to give me your email. So one takeaway is, when it comes to your apartment, I want you to save everything. Save everything. Cyber storage is so cheap these days. You probably have like 1 million pictures saved somewhere online. So save all the texts and emails that concern your apartment. Maybe develop a system where you periodically dump all that material into some kind of well-identified online drive somewhere. Have a folder for your apartment because you never know when this stuff will be important. You would be shocked at how many people don't even have a copy of their original lease when they come to me, which the original lease can be so important. Now, the other takeaway is that this rule works both ways. Landlords need to be preserving information relevant to any controversies with tenants. So I'm making up a scenario here. Let's say the big issue in your case is, did the landlord really send a plumber on the 15th at 10 a.m. when she was supposed to send a plumber? You took the day off from work for this appointment. No plumber came. The landlord says the plumber did come and you didn't answer the door. Who is telling the truth? The landlord has some paper from the plumber saying someone came and you didn't answer the door. Well, that's easy enough to manufacture, especially if the landlord has a long relationship with the plumber. So what if you said to the landlord, Ms. Landlord, this building only has one front entrance and there's a security camera there. I want to see the footage from the 15th. I want to see if the plumber really walked through the door. Now, the landlord says, sorry, that was 6 weeks ago, and we only keep 30 days of footage before the data gets written over on those cameras. You could potentially say here, hey, Ms. Landlord, you knew that this was a big point of controversy between us, and that tape would prove that you really sent the plumber that I took the day off from work to wait for, and you destroyed it. The judge in this case should assume an adverse inference against landlord when considering which of us is telling the truth. I'm just saying. And there you have it. Remember, New York City, the law belongs to you, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is the Tenant Law Podcast.